Hello, my name is Dan Gomez. I'm a debt relief attorney in San Diego. When a creditor sues you and obtains a judgment for unsecured debt, such as credit card debt, the next step is for the creditor to collect on that judgment. In California, the easiest ways for a creditor to collect on a judgment are to garnish your wages. If your creditor has done some research on you, they likely know where you work and possibly where you bank. It's not that difficult for them to find out. California law states that a judgment creditor can garnish up to 25% of your wages until the judgment is paid in full. Your employer cannot ignore this and must garnish your wages as mandated by the writ. The only bright note is that your employer is not permitted to terminate you simply because you are having your wages garnished. So let's take a look at what happens here and how you fight back against these collection methods. The first is timing. If you receive a notice that a judgment has been entered against you and your creditor is seeking to garnish your wages, you need to act immediately to stop the wage garnishment. It is possible to reach an agreement with a creditor before your employer is required to start garnishing your wages. For instance, my client had a judgment entered against her and her employer received notice of a wage garnishment by Citibank. She had no idea about the judgment until she received a phone call from her HR department letting her know that they received notice to garnish her wages. She called my office for a free consultation, and within an hour of returning me, we had reached an agreement with her creditor to reduce the judgment amount by 25%, cease accrual of post-judgment interest, and allow our client to pay the negotiated amount over a 6-month period in a payment plan. Our client was so relieved she didn't have to face the embarrassment of her employer taking her wages to pay this judgment. The second key factor to stop a wage garnishment is to convince the court that your wages are needed for the basic necessities of life. Here's a recent example of how I fought our client's wage garnishment. LBS Financial Credit Union sued my client, obtained a judgment, and sought to garnish 25% of her wages, which would total $1,200 a month. We filed a claim of exemption, arguing that the amount would present an undue hardship for her financially. She needed that money for the basic necessities of life. At the hearing, the court agreed with us and reduced the wage garnishment to $50 per month. Immediately after that, we were able to settle with LBS for a one-time lump settlement for less than the balance due. If you still have questions about wage garnishment, then contact me for a free consultation. I'm happy to answer any questions you have about your debt relief options. You deserve an honest opinion on all of your options when facing collection on a judgment. In some instances, it may be best to consider bankruptcy. If that's not a good option for you, it may be possible to negotiate a debt settlement with your judgment creditor. Everyone's circumstances are different, and you should know your options. If you enjoyed this video, be sure to hit the like button and subscribe. And if you know somebody that needs a little help getting out of debt, be sure to share this video with them. For a free consultation, visit GomezLawFirm.com.